Ms Crown.
We'd just turned to look at Regulation 8 of the 2014 regulations, and I'd like to go back to that, please. And we were talking about a constable may be suspended if an allegation comes to attention of Police Scotland from which it can reasonably be inferred that the conduct may be misconduct, gross misconduct, or a criminal offence. So some consideration again required, but the constable may be suspended for any of those reasons. Subparagraph 2, but a senior constable must not suspend another constable unless at least one of the conditions mentioned in paragraph 3 is satisfied. So the officer must not be suspended if at least one of the conditions is satisfied. Is that correct?
Yeah, one of those conditions must be satisfied in order for the
one must be satisfied.
Grounds for, at least one, the grounds for suspension to be satisfied.
Right. So he cannot be suspended unless at least one of these two conditions exists and is satisfied.
They should not be suspended, yeah.
And it does say must not be suspended. So the suspension conditions are that A, an effective criminal or misconduct investigation may be prejudiced if the constable is not suspended, and B, if we can move up the screen, having regard to the nature of the allegation and any other relevant considerations, the public interest requires the constable's suspension. And I'm interested in your experience of how consideration is given to whether either of these conditions exists, is satisfied. And if we can maybe go back to A. So an effective criminal or misconduct investigation may be prejudiced if the constable is not suspended. Now clearly, if there is no criminal investigation underway or misconduct investigation, that cannot be prejudiced. So if that has concluded, matters have resolved, that cannot apply. But in relation to lost my train of thought there, sorry. Can we move on to B, first of all? Having regard to the nature of the allegation and any other relevant considerations, the public interest requires the constable's suspension. I've just remembered what I was going to say, sorry. Could we go back to A? Just sorry about that. I was going to ask you about, we said if the criminal investigation has come to an end, that's obviously not a condition that can be satisfied. It could not be prejudiced once it's concluded. But in a situation where there's a criminal investigation ongoing, how do Police Scotland satisfy themselves, and in particular you or one of your delegated officers, satisfy themselves that there may be prejudice to the criminal investigation? Do you contact PERC? Do you contact the Crown? What do you do?
So to give you an example there, and clearly it's only one example, the prejudice may occur if, for argument's sake, the officer remains in the workplace, they are restricted rather than suspended, they still have access to force systems, they may delete material from force systems, or they may go back into aspects of, reports or policies or pro formas that they shouldn't have access to. So there's something about if an officer is suspended, then generally their access to force systems are removed. So there is no opportunity for them, if you like, to tamper, and I use that word advisedly, with any of the evidence or the material which may form part of the conduct or criminal proceedings. The other issue, or the other aspect of prejudice if the constable is not suspended, is whether that constable would bring undue pressure to bear if they were still in the workplace, potentially on other colleagues who may be witnesses. So there is there is again a rationale for suspension, and you will get this counsel in much more detail for those who are doing this on a day-to-day basis. But there is also a rationale around if that individual officer were to remain in the workplace, would they have the opportunity to attempt to put pressure on any of their colleagues to change what they might say in the course of the investigation.
How common is it to suspend an officer if the view is taken that there's been misconduct, gross misconduct, or a criminal offence?
So, suspension is not common. I'm just trying to, and forgive me, I can't remember the number of officers who were suspended when I retired from Police Scotland. I have a feeling it might have, I genuinely can't remember. There's a figure in my mind, but I'm not sure whether it's right. But it's a very, very small subset of police officers within Police Scotland. I think it's around about the very, very low three figures, but please don't take that as the actual situation with officers who are suspended. We'd need to check the figures for you, which we can do. But it is a small number who are suspended, but if the situation and the circumstances warrant the suspension of an officer, then they will be suspended. But the numbers are small. There are far more officers who are under investigation who are restricted on restricted duties remaining in the workplace than there are suspended.
But someone would be applying their minds to the question of whether an effective criminal or misconduct investigation may be prejudiced, and that their mind would be applied to that. They would give consideration to that before a decision is taken regarding any suspension or restriction of duties.
That's right. So in terms of any suspension, yeah.
And is a report prepared? Is there a document prepared which sets out the reasoning?
So yes, there is a, as we discussed, I think just before lunch, my recollection is that there is a document which is completed by colleagues in PSD. Again, I think from memory, and this may have changed since I retired from Police Scotland, that document is then presented to one of the superintendents within PSD, setting out the rationale for a decision to suspend. That will then go to the ACC professionalism, again to the best of my recollection, and the ACC professionalism is the ultimate decision maker and weighs the evidence that has been provided to him. It was a him at that point in time.
And if the question is asked, consideration is given, and a decision is taken not to suspend, but that process has been followed, is that also something that's noted in a report or a document of
that
some
would be,
kind?
again, because I haven't filled these documents in myself, I'm slightly wary about describing them to you, but what I would anticipate would happen is that there will be the rationale for agreeing suspension, or actually saying, well, no, I don't think this meets the threshold for suspension, but it may well meet the threshold for restriction, either on the same document or on a document which is attached to the overview for the ACC to take a decision on suspension.
And do you ever see those documents as part of a discussion, a wider discussion with you as DCC?
I don't recall ever seeing the documents, no. I don't recall ever seeing the documents.
So in your role, would that have been information shared through a conversation with the ACC?
Yes.
But if that question has been considered and an assessment's been made, then there will be some document of some description that we can recover.
Yes.
And let's look at B, please. So this is the second condition. Having regard to the nature of the allegation and any other relevant considerations, the public interest requires the constable's suspension. And again, is this something that is assessed to see whether that condition can be satisfied?
Yes.
And is the same process carried out?
Yes.
And a document prepared?
Yes.
And recommending suspension or restriction or nothing.
Yes, yeah, that's absolutely right. And those documents, and again, I am talking to you slightly at arm's length here because, as I say, that's the role of the Assistant Chief Constable rather than myself. But those documents, as I say, will be reviewed relating to individual officers on a 28-day repeating cycle to ensure that the conditions for that officer's suspension remain valid.
How is the public interest assessed?
So that will be predominantly around public confidence in policing in Scotland and what a reasonable person might expect the police service to do should an officer engage in a particular type of conduct.
Right. And is there a particular source used to assess what the public interest is, or whether public confidence is high or low, or?
So again, that's quite a complex question because again, I think public interest may actually vary depending on the circumstances that the individual officer is suspected of. For example, if an officer has engaged in racist conduct towards members of the public or towards their colleagues, if the officer has been involved in acts of domestic abuse or domestic violence or violence against women and girls, because of the sensitivities, because of the acute nature of the public interest in issues, rightly so, in issues such as those, the public interest test for certain types of behaviours may be slightly different to the public interest test for others. For argument's sake, if an officer had been found to have been drink driving, for example, the public interest in suspending that officer as a consequence of their having been drink driving might be different to the public interest test if an officer was suspected of being racially discriminatory towards members of the public.
How would you describe the public interest in a situation where a black man has died after having come into contact with the police?
Yeah, I think that's acute.
Acute. So in relation to Mr. Bio, you would say that was acute?
Absolutely.
So if the regulation requires one of these conditions to be satisfied, are you able to help us understand why this condition about public interest requiring the constable's suspension was not satisfied in this case?
So again, it's difficult for me to talk to the situation back in 2015. As I've explained in terms of the period of time where I was in Police Scotland, there were still other sort of processes ongoing. The officers were still in the workplace. I can't remember, counsel, whether any of them were restricted or were potentially away from the workplace.
I'll be corrected if I'm wrong, but I'm not aware of any suspensions.
I don't think there were any suspensions.
I'm not aware of any restrictions. I'm aware that 2 officers at least were off sick.
Yes, and officers have subsequently retired.
Yes.
Yeah.
But I'm not aware of any restrictions on their duties or suspensions.
Yeah.
No one's shouting out that I've got that wrong,
No.
so I think that's probably correct.
Yeah, I think that's correct.
So, bearing that in mind, clearly they weren't suspended here. They weren't put on restricted duties. But public interest was, as you said, acute.
Yeah,
Can you explain?
And that public interest and the confidence of communities, I think, has to be supported by a rigorous, an independent and a thorough investigation into the circumstances of any incident or event. So certainly the public interest would be I think, absolutely engaged in the death of a young black man at the hands of police officers. But also I do think it's important that a thorough investigation is carried out to understand the circumstances that pertain to that tragic, sequence of tragic, or that tragic sequence of events.
And where that public interest is strong, acute, as you put it, and there is also at the same time going to be an investigation, Is there a view when you were in the role, was there a view that if the investigation is rigorous, independent and thorough, that is a counterbalance to the public interest in having the constable suspended?
I think it can be, yes. I think it can be, but again, referring back to the set of circumstances this morning, that I described this morning, I think both of those conditions were met in terms of that particular suspension, involvement, potential interaction with an ongoing investigation, but also because of the nature of the allegations, the suspension was required to maintain public confidence, notwithstanding the fact that there was an independent investigation being carried on by the PERC at that time. So again, every set of circumstances, I think, should be regarded on its own, taken on its own merits.
Right. And in what, can you help us understand where the range lies, where you have a very strong acute public interest, perhaps in favour of suspending the officer, but an independent investigation being carried out? Now, you've talked about one example where the balance was that officer should be suspended, and you've talked about the public interest in that case being so strong. To what extent was the public interest in that case, so I appreciate you don't want to give us the circumstances, but to what extent was the public interest in that case even more significant or even less significant than in relation to the death of a black man?
Very different. Very different. And that's I suppose, the point I've probably clumsily trying to make about public interest isn't homogenous. There are any number of sets of circumstances potentially that could engage the public interest. They're not all the same. They can be very different, and of course there's a huge difference between what the public is interested in and a series of events which actually it is in the public interest as a consequence to suspend an individual officer. So it's that contrast, I think, doesn't necessarily. That contrast between sets of circumstances doesn't necessarily mitigate against suspension in one case and not suspending in another. I think every set of circumstances should be taken on its own merits. And of course, what I should say is that PERC investigation, rigorous, robust, independent, the officers as well, need to be sort of considered, their welfare and their well-being in all of this.
In assessing condition B or in assessing either of those conditions?
So I think back to the point of, well, we could suspend, but is it better to keep an officer in the workplace because one or other of those conditions may not apply counsel?
Right. Obviously, the family are members of the public.
Of course.
Was there any part of that process regarding public interest? Did any part of that involve finding out the family's views?
Back in 2015, I'm not sure. I don't know at that stage, but certainly by the time I was a DCC within Police Scotland, and there were various processes in train in respect of the subject officers in the investigation of Mr. Bayo's death. I don't recall speaking to the family specifically in respect of, or the family having the opportunity to speak to Police Scotland specifically in the context of, will Police Scotland suspend the officers?
When you were in the role, obviously at a later stage, 2018 onwards, was that something that you would have considered to be a relevant consideration in the assessment of condition B?
Had I been in the role in 2015?
No, when you were in the role in 2018 onwards, did you consider taking account of the family's views when you were assessing condition B about public interest?
I would hope always to take account of the family's views, yes.
So there'd be nothing to prevent Police Scotland from taking account of the family's views if they wish to?
That's right, through their proper sort of legal representatives.
Legal representatives, thank you. Can I move on in the regulations to Part 2, misconduct investigations, and I'm particularly interested in Regulation 10. So this is Part 2, and this is preliminary assessment. Now, I'm going to read this out, but I will be asking you some questions about some of the evidence you gave earlier today. So this is an assessment within the terms of the regulations. It's called a preliminary assessment. And it says this regulation applies if a misconduct allegation comes to the attention of the Deputy Chief Constable. The Deputy Chief Constable must assess whether the conduct which is the subject matter of the misconduct allegation would, if that conduct were proved, amount to misconduct, gross misconduct, or neither. Now, earlier today we talked about an initial assessment carried out by the Professional Standards
Yes.
Department. And that was separate from the regulations. I made a point of saying I want to know. This is an assessment carried out within the body of the regulations. Having looked at that now, can you tell me, this initial assessment you were talking about, was this completely separate from the regulations, or was it under Regulation 10?
So sorry, just help me out here, Council. The initial assessment.
Do you remember your evidence this morning about, I was asking about an assessment being carried out, and we started talking about an initial assessment being carried out as to whether or not there was any misconduct, and you'd talked about an honest mistake.
Mm-hmm.
So an assessment was carried out, after which the decision may be taken that this will be rerouted or diverted
Yes.
away from the regulatory framework. And we talked about that at some length, and then what we see here is an initial assessment about misconduct, but this is within the regulatory
Yes.
framework, and I want to just be quite clear if I've completely understood your evidence on this.
So yes, that initial assessment, if an issue surrounding the conduct of an officer comes to the attention of a senior constable, should be done within the confines of or should be carried out within the confines of Regulation 10.
Right. So it's not as if there's an informal, non-regulatory assessment being carried out. It would be an assessment under Regulation 10.
It would be an assessment under Regulation 10, and there are various routes then off of that initial
Yes. assessment
under Regulation 10. Again, what I would say, Council, is I am right at the right-hand side of my personal experience, because I did not carry out these assessments myself. They were delegated to the ACC and then clearly carried out by individuals within the Professional Standards Department. But Regulation 10 is the assessment, if you like, process for conduct.
So it comes to the police attention that there's an issue about someone's conduct. That awareness then triggers an assessment under Regulation 10.
If the conduct rules are engaged.
And yes,
Or the
if
conduct
there's
regulations
if it's
are
a
engaged.
feeling of the standard professional standards, and an assessment will be carried out, and that assessment will cover the question of whether this could be misconduct, gross misconduct, or neither. So it could be an honest mistake, a genuine error, and it will then be diverted away from the regulations if that's the case. But there will be that assessment carried out.
Yes.
Right. And some will be diverted, and some will remain within the regulations and then follow whatever route is required depending on the conduct.
Yes. But that, I have to say, Council, is very high level from a DCC's perspective. Let's say the granularity that you would get around that process from speaking to a practitioner would be much greater than that which I can furnish.
No, that's absolutely, thank you. Thank you for clearing that up. I would like to move on now to some events that took place in 2019. And still under reference to the regulations. And one of the things I'm interested in is an opinion of Lord Woolman in relation to a petitions for judicial review, and you've talked about people retiring.
Yes.
And this is in connection, it's a public document, it's in connection with the applications for judicial review by PC Payton and PC Short. Now, we've heard both of them were absent from work through ill health for a period, and we're aware that they sought to retire on the grounds of ill health, and that petition was lodged in relation to that, because I think there was resistance from the Scottish Police Authority for their retirement. And I'm interested in exploring this issue about retirement and the misconduct proceedings. Perhaps we should look first of all at the opinion, which I understand is available on the screen, although, as I say, this is a publicly available document. And it's from 2019, and you'll see their opinion of Lord Woolman, and the date is April 2019, if we move down the screen. There we are. And it relates to the circumstances surrounding Mr. Bio's death. And as I've said, both of these officers wished to retire. That was declined, and they then sought judicial review of that matter. Can we look at paragraph 4 first of all, please? And so you'll see the officers challenged the decision of the SPA, advanced arguments in relation to why they felt they should be permitted to retire, and in relation to the judicial review against the decision by the SPA that they should not be permitted to retire. And I'm interested in looking at C. So it says, the decision is irrational having regard to, and there's 3 categories, 3 lines of argument presented. And C says the absence of any intimation to them that they will face either prosecution or internal disciplinary proceedings in respect of Mr. Bio's death. And then if we look at paragraph 8, it's noted in the opinion that, at the very last sentence, they have not received any intimation that they face misconduct proceedings in connection with the incident. And so it would appear that at this stage, by April 2019, none of the officers who attended Hayfield Road had received any intimation at any time that they faced or may face misconduct proceedings. Was that your understanding of the position at that time?
Yes.
Yes. And when you came into your role in 2018, did you ever have a discussion about whether misconduct proceedings should be commenced or initiated against the officers?
So I think there was always an anticipation council at a point in time where we were in possession of the and this of course precludes the setting up of a public inquiry, but there was an anticipation at some point when we received the relevant documentation from the PERC, then that would be assessed by colleagues within the professional standards department, and determinations around whether there should or should not be any conduct processes taken forward, as we discussed before lunch, would be made.
So that would be at the point you had documentation.
Yes.
That would allow the police to carry out an assessment.
Yes.
In terms of the regulations, and it would trigger the process at that
Yes.
stage. So for officers who, obviously in this case, 2 officers wished to retire, and we've heard ultimately they did. Now, what can Police Scotland do where officers ultimately do retire? What can Police Scotland do in relation to misconduct proceedings?
So that's a very good point, and this is clearly this is medical retirement, which is in the gift of the Scottish Police Authority. At the moment, and this may change as the Conduct and Ethics Bill goes through Parliament. At the moment, if an officer decides to resign or retire whilst they are facing misconduct, or indeed gross misconduct, misconduct or a gross misconduct investigation, investigation within Police Scotland, we can't prevent them from doing that.
And once they have resigned or retired, is there anything that Police Scotland can do in terms of assessing misconduct, perhaps sanctioning an officer if they are found to have acted contrary to the professional standards?
So at the moment in Scotland, once an officer retires, they are no longer an officer. Therefore, they are not subject to Police Scotland discipline in any way, shape or form. Now, if an officer who is facing a criminal investigation resigns or retires, then of course that criminal investigation can continue to its ultimate conclusion. But when an officer resigns or retires, and you know, it is in policing in Scotland very often an officer will resign before they are put through any conduct process. The conduct process at this point in time falls at that stage.
And that's due to change?
That may change depending on the
change
legislation,
depending on
which is making its way through the Scottish Parliament at the moment.
But in that situation where they resign or they retire, they are no longer subject to any misconduct proceedings. No. They cannot be sanctioned by Police Scotland, and they cannot impose any penalties or anything of that sort.
No, that's exactly right. And you know, I don't know where the bill which is currently working its way through Parliament, where that will end up. But where I am very clear in my mind is that if an officer resigns or retires in advance of facing particularly gross misconduct investigations, then there should be consideration given to whether that officer should go on what we knew in England and Wales as a disbarred officers list, which would bring some sanction into play, Council. Now that is not an option which is available to us at the moment, but I know it, or I believe that's something that the bill making its way through Parliament is addressing. Whether if somebody does resign or retire, in advance of facing gross misconduct process, then is it possible to put some kind of sanction on that individual subsequently, which means that they wouldn't work in policing at any point in the future.
I believe it's public knowledge that officers may retire in their 50s and then go on to have a second career. We've had a number of witnesses talk about that in this hearing. And they may go on and do jobs working in the field of security or some other area. At the moment, there's nothing to prevent them doing that, even if they were subject to quite serious, potentially serious misconduct proceedings. Could they become PERC investigators?
That's a question for PERC.
All right. But they could have jobs in other areas, including security, including investigations, where they would not be sanctioned as things presently stand today. So
again, quite a complex environment. Obviously, whoever an individual officer's new employer would be, one would anticipate they would do some vetting of their own right. The difficulty, of course, is that when an officer resigns or retires from Police Scotland, when we are asked about the status of that officer, then we will say, well, they have resigned or they have retired. So there is a lacuna there. There is no doubt about it. Again, I do draw a distinction between, if you like, statutory agencies, other police agencies, whether that's the NCA, the Ministry of Defence Police, or a police service in England and Wales, as opposed to an officer taking up employment within the private sector.
Before you retired, if an officer, a former officer, requested a reference, and that officer had been subject to misconduct proceedings, which were brought to a halt by their resignation or their retirement, was it part of the reference that would be raised with the person seeking the reference?
So I'd need to check that. I think that the circumstances would be related simply that the officer had resigned or retired from Police Scotland. I don't know whether we would include the fact that they had resigned or retired whilst they were facing misconduct or gross. I genuinely don't know the answer to that.
We can perhaps find that
That,
out.
yeah, absolutely.
So it's possible that someone who resigns to avoid the questions being asked in misconduct proceedings, that he could go on or she could go on to have another career, and for that not to be something the new employers were aware of.
Potentially. As I say, I'd need to check the current situation with colleagues in P&D, our HR department, and PSD about how that set of circumstances would be dealt with in 2024 if a request for a reference came in regarding an officer who had resigned or retired in those circumstances.
And if an officer retires in this situation, their pension would be unaffected?
So if an officer resigns and it's early in their service, then there will be a financial detriment. There is no doubt about that. The police pension wouldn't be paid when it might normally be paid if you retired under the normal scheme of things. If however, an officer has reached retirement age and chooses to retire, then you're absolutely right. They would potentially be able to crystallise their pension with the service that they had at the point which they retired.
And if they are medically retired, does that encompass an enhanced pension, taking account of medical reasons?
It can encompass an enhanced pension, yes.
Let's look at paragraph 18. This is, on the screen we still have the opinion of Lord Woolman. On the 22nd of November 2018, the SPA wrote to ask the PERC whether it had found potential grounds of misconduct on the part of the officers. So this was the November prior to this opinion. This opinion was April 19.
Yes.
So this is the preceding November. And it's, as you say, the question of whether the person should be allowed to retire, medically retire, is within the gift of the SPA. And they've written to ask PERC whether it had found potential grounds of misconduct on the part of the officers. And the PERC gave this inquiry short shrift. It replied that it was not part of its role to report on questions of misconduct. So certainly in November 2018, it would appear that PERC, is it fair to say, did not consider questions of misconduct to be part of their role if they were involved in an investigation.
So again, counsel, I would need to check my recollection of this, but I don't know if PERC were actually even able to consider misconduct on the part of officers up to the rank of Chief Superintendent. I think the conduct space for PERC was engaged with PERC would potentially be engaged with investigations into chief officers. But again, that's my recollection.
I think that may be correct. We've heard evidence about
that. I would need to check that.
So in terms of even asking, even in 2018, asking PERC for assistance to consider potential misconduct, it's described here as them giving short shrift to that type of request. So unlikely that PERC would assist at that stage or prior to that.
That seems to be the case.
And then can we look at paragraph 21? Here, the DCC has not told the officers that they face any proceedings or that any such proceedings have been suspended or postponed. I think that's correct, isn't it?
That's my recollection, yes.
And then 27. Lord Woolman asks two questions. Can we go to just above that, please, just so we can see the section that we're, if we can keep going up. This is to do with the decision on irrationality regarding the judicial review proceedings. So if we can turn to paragraph 27 again, please. No one has suggested that the officers are culpable to any degree in respect of the incident. The SPA itself relies on an unspecified involvement. One may ask two questions. How could they now be charged, given that they have been questioned at length without being cautioned? And how could the DCC institute misconduct proceedings given the lapse of time and absence of any intimation? And I'm interested in the comments by Lord Woolman about how could the DCC institute misconduct proceedings given the lapse of time and absence of any intimation? Is that something that you were having regard to when you were considering, if you ever considered proceedings under 2014, the 2014 regulations? The delay which is being caused by the involvement of PERC, the involvement of other matters, the lack of disclosure of the PERC report. Given the lapse of time, I mean, we're talking about events in 2015. This is a decision from 2019, almost 4 years later, and the absence of any intimation of misconduct proceedings under the 2014 regs.
I think there is no disagreement that the length of time that these matters have been have been working through various processes is far from satisfactory for the family, and that is very, very suboptimal.
And certainly with the regulations, it would appear that it's not that they're being worked through, it's that any question or any consideration is being deferred.
So again, there's the piece that we discussed this morning about having disclosure from the PERC, understanding from the statements they've taken, from the evidence they've gathered, from everything that they have accrued and distilled from the events in 2015. If there is no criminality, then what does that mean in terms of we go through that conduct assessment, and then, as you say, the more time that elapses, the less satisfactory the circumstances are for all concerned, Council.
And can we look at paragraph 31? I'm interested in the part that starts, specifically there was no foundation. They were in the middle, specifically in brackets. Do you see that in the middle of the paragraph?
Yes.
Specifically, there was no foundation for inferring that either officer might be criticised for their conduct that day, and that relates to Peyton at former PC Peyton,
yes,
and former PC Short. And so the Lord Ordinary took the view there was no foundation for inferring that either officer might even be criticised, never mind any suggestion of misconduct, gross misconduct or criminal proceedings at that stage. Yeah. And that will be correct, as I understand it. There was no basis for making that inference.
At that point in time, that's absolutely correct.
I mean, we've talked about the period of time that has taken, and at this stage it was 4 years from the date of Mr. Bayo's death. The inquiry understands that that was in April 2019, and then, as I understand the position, in the month after this, there was some contact with the family. And they wrote to Ian Livingston, the Chief Constable, about this, formally asking that a criminal complaint be brought to the attention of the Chief Constable, and commenting specifically in relation to this opinion, and talking about the public perception and concerns that they had, wide-ranging concerns about public perception, criminality, race, issues along those lines. And after this decision by Lord Woolman, and then in light of the letter from the family to the Chief Constable, were you aware at that time as to the extreme concerns that were being expressed by the family?
So I can't remember. haven't seen that letter, certainly not recently, so I'm unfamiliar with the content of it, or certainly not familiar with the content of it. But I have been aware, Council, that of the family's concerns throughout.
Right. And during that period, say from April 2019, after this decision, May 2019, when the family were in contact with Chief Constable, and the November of that year, so between April and November of 2019, the public inquiry was announced in November. What did Police Scotland do in that period of time, after this decision from Lord Woolman and prior to the announcement of the public inquiry, about making progress in relation to the possible conduct issues under the 2014 regulations?
So I would need to go back and refresh my memory, because I don't know what happened with the complaint which came in, to which you refer, Council. I have no, I don't recall what happened to that. The letter would have been directed by the Chief Constable.
We hope to hear from the former Chief Constable.
Fine.
We can ask him.
That's absolutely fine. Whilst the public inquiry was intimated formally in November 2019,
Yes,
I think
an announcement was made.
the announcement was made. I think in advance of that announcement, and again I'd have to go back and just check the dateline here, Council, I think there was intimation to potential core participants that a public inquiry was going to be held before that public announcement was made.
Right.
So I think we would have understood at some point. Now again, I can't be specific because I don't have the letters from Mr Yusuf, then the Justice Secretary, to the Chief Constable in front of me, but I think we were aware before November that there would be a public inquiry held into the death of Mr Bio.
And how long before?
I can't remember.
So this decision from Lord Woolman was April. The family were in touch with the Chief Constable in May. How long before November would? So
I genuinely can't remember, and of course there are two issues. There are the issues that the family rightly raised about ex-constables Payton and Short, and then there is that broader piece around Crown and victims' right to review and the other subject officers. So I find it difficult to answer that question because there were a number of issues in train at that point in time. What I would say is that the organisation was still very seized with the fact that Mr Bio had died. There were still goal groups going on. The circumstances were being considered. But I can't remember what happened. I can't remember what happened with that letter.
Right. And do you remember if any steps were being taken before the announcement about the public inquiry, or before you became aware of that, in relation to progressing matters under the 2014 regulations? So
I can't remember whether we were requesting PERC at that point in time, or asking PERC at that period, post the victims' right to review, as we discussed this morning, whether we could have access to the file or not. I genuinely can't remember. I don't know whether there was enough time to enable that to happen, but again, I couldn't define that timeline for you this afternoon.
Right. Now, in 2020, I should say, the inquiry officially commenced on the 30th of November 2020. Yes. We started to seek documentation at that stage, and the first documents we received were the following year, 2021. So that's what was happening with the public inquiry. In 2021, on the 14th of October, volumes 1 and 2 of the PERC report were disclosed to Police Scotland via the inquiry. And on the 14th of December 2021, volume 3 of the PERC report was disclosed to Police Scotland via the inquiry. At the point at which you received disclosure of these documents, what steps, if any, did you take in relation to the 2014 regulations and any assessment to be carried out?
So I don't think we did at that stage, Council.
You don't think you got disclosure on those dates?
No. I think we got disclosure, but I don't think we went back to the
Oh, I see.
2014 regs
Right.
and carried out an assessment. Again, if you you will be aware that in the run into a public inquiry, we would be taking as an organisation some significant and very thoughtful legal advice around what steps we should take. Very, very clear that we did not want in any way to undermine the public inquiry. But from to the best of my knowledge and recollection over that period, there wasn't an assessment carried out on the volumes of material that PERC released to us. Now, I may be wrong, but that's my recollection.
Thank you. And then can we look at your inquiry statement, the relate response? That is SBPI 00546. And I'd like to look at paragraph 10. It's on the screen. I made the decision that an undertaking would not be provided to the inquiry, that officers giving evidence would not face conduct proceedings. The rationale for my decision is set out in my letter dated 25th March 2022. I'd like to look at that letter, please. SBPI 00634. And you'll see that this is a letter from Police Scotland to the chair of the inquiry, and the date is actually at the very top of the letter, which is 25th of March 2022. And a request had been made in relation to undertakings. I don't know if you recollect the circumstances. And you had been requested to provide an undertaking in relation to disciplinary proceedings against individual officers.
Yes.
Oh, individual serving officers, because as I understand the position at this time, both PC Payton and PC Short had retired, medically retired. So of the remaining serving officers who remained within Police Scotland. And I think no undertakings were given. And I think if we look at page 2 of the letter, please, and in particular paragraph 2, you point out that it was a matter of consensus that the privilege against self-incrimination does not apply in disciplinary proceedings. And I'm interested in this aspect. We've obviously, and as part of this process, we looked at the privilege against self-incrimination. And that was very much a live issue in relation to possible criminal proceedings. Yes. And also in relation to evidence given under oath to the inquiry. And you've pointed out in your letter that the privilege against self-incrimination doesn't apply in disciplinary proceedings. And I'm interested in that aspect of your consideration of misconduct proceedings, and if there is a tension where there's a criminal investigation ongoing, but you know they have a right to the privilege, to exercise the privilege in that situation, but not in relation to misconduct proceedings.
So I think that, and again, I go back and look at the legal advice that I received, counsel, in terms of drafting that letter to the chair. But my understanding was that case law suggested that that there was not a right not to, I know that's a very clumsy way of putting it, a right not to self-incriminate within a discipline environment in the same way that there would be within a criminal environment.
So in a criminal environment, the officer should be entitled to say, I have the right not to incriminate myself, and they can rely on that.
Yes. And
because of that right, I'm going to exercise that right, and I'm not going to answer any questions. And that they don't have that right in misconduct proceedings. I think that's what you're saying there.
That's my understanding. Again, I'd go back and check the legal advice that I received in preparing that letter to come to the chair.
I'm interested in how Police Scotland resolve that issue, where you have the possibility of considering misconduct proceedings. You know there are potentially criminal proceedings, and there's a right to not to incriminate oneself. But that doesn't exist in misconduct proceedings. Can you help us understand, do you have regard to the right, the privilege against self-incrimination?
So I think it's also important just to highlight that a number of the officers weren't looking for any undertaking from myself. They didn't need an undertaking from myself to, if you like, protect them from any possibility of self-incrimination as far as conduct was going, because actually we talked about our standards of professional behaviour earlier. They felt that it was absolutely the right thing to do, to come to this inquiry and to be absolutely candid with the inquiry and not require any guarantees, if you like, from myself around anything that they may have provided in evidence, potentially being self-incriminatory as far as any future conduct proceeding is concerned.
And in relation to the undertakings, you declined to provide undertakings. Was that because you took the view you may wish to initiate, consider, commence misconduct proceedings against the officers?
I think that was always the case, and certainly, again, just reflecting on some of the legal advice that I think I was provided at the time, very careful about the issue of privilege, obviously.
Obviously, I don't want to encroach on that.
No, and you know, there is case law in terms of other public inquiries, as I recall, which suggests that even if there was any comfort given by the discipline authority as opposed to any criminal authority, it would predominantly cover simple misconduct as opposed to gross misconduct. So there was also that differentiation in my mind around simple misconduct and gross misconduct, which might ultimately lead to a serving officer, if it was proven, losing their job.
But in terms of your position in 2022 at least, did you still take the view that it would have been open to you at that stage, regardless of the delay, in initiating or considering or commencing misconduct proceedings under the 2014 regulations?
At the conclusion of the inquiry, absolutely.
So the position was you would defer consideration or assessment until the conclusion of the inquiry?
Yes, given that there are two aspects to that. The first is the material that was collated by PERC in the context of the PERC inquiry, and then secondly, there would be the issue of the evidence which was provided by those officers around the circumstances in May 2015 to the chair of the inquiry.
And at the time you left, at the time you retired, did it remain your position that consideration of proceedings under the 2014 regulation would be given at the conclusion of this public inquiry?
That was my anticipation, yes. As I say, both in terms of the initial incident back in 2015, but also the conduct of the officers over the course of the public inquiry itself, should that become an issue. And I'm not suggesting for a minute that it has, but should that become an issue.
If you could give me a moment, I'm conscious that we're just after 2.
We'll take a 15-minute break. Ms Graham.
Thank you. I'd like to remain with the letter for the moment, 25th of March 2022, and I'd like to look at page 2 and paragraph 5. There we are, and it starts: the rights of the bereaved family of Sheku Bayo are at the centre of the inquiry. As stated in the submission on behalf of the Chief Constable, their Article 2 rights encompass not only the carrying out of thorough, diligent and comprehensive inquiry, but the duty also requires there to be appropriate provision for disciplinary action. So, and I think you've mentioned earlier that you take the view that in carrying out, where there's been a death at the hands of the state, in this case, after contact with the police, that Article 2 rights will be engaged. And I've asked a number of witnesses about this, and you said that as part of carrying out this thorough, diligent and comprehensive inquiry, there is a duty that also requires there to be appropriate provision for disciplinary action. And that would be what is, the framework at least, is in existence in the 2014 regulations.
Yes.
And I'd like to ask you a little bit more about that. We've heard about Article 2, and as part of the investigation, we've heard evidence from PERC, from Crown Office, from police officers about the investigation that was carried out after Mr. Bayo died. And as part of that picture, there is the 2014 regulations, and we're hearing from you in connection with that. We've heard that there are 5 procedural obligations under Article 2, and you may have heard some evidence in relation to this, but if I can put it shortly: independence, adequacy, reasonably prompt, public scrutiny and next of kin. And I'd like to just ask you some questions about those 5 obligations. In relation to the question, first of all, of independence, you've talked, there's 2 things I'd like to cover in this aspect. First of all, under the regulations, it is a DCC who is responsible for considering, assessing, categorising, instigating, commencing possible conduct proceedings. It is a fellow police officer from Police Scotland. Do you have any concerns about the question of misconduct and the application of the regulations to any given situation? Do you have any concerns about fellow officers carrying out these tasks in relation to other officers who are also within Police Scotland?
So Police Scotland is a very large organisation, some 23,000 I think at last count, some 23,000 police officers and police staff. So I do think that there is sufficient distance between the officers who will carry out that conduct assessment that we've spoken about this morning, who sit within a very specialised team in the department, in the professional standards department, and officers who may be geographically deployed anywhere else across the country. So I think the structures and the systems that we have in place are sufficiently robust to ensure that there is proper independence and no unnecessary sort of pressure or influence brought to bear on those police officers who investigate other police officers. We have recently, and again I'd need to go back, Council, and just check my recollection on this, but we have recently put further safeguards in place, as I recall, to ensure that there is proper independence and a lack of any, as I say, likelihood of undue influence being brought to bear, not just in terms of the investigation into a death like this, but investigations which take place up and down the country on a day-in, day-out basis. Again, Council, you'll have been aware of comments, conversations, concerns about officers who are suspected of committing a domestic abuse offence, being investigated by colleagues. The victim, if you like, the complainant, therefore, potentially doesn't get the quality of service in terms of the investigation they should get, because the suggestion that there's an old boys club, if you like. So certainly in Police Scotland, we are very, very aware of the optics of having a discrete and independent professional standards department carrying out these conduct assessments and indeed on occasion investigation into other officers within Police Scotland. And of course the regulatory framework, as we discussed at the moment, and we discussed this earlier, means that actually it does fall, again to the best of my recollection, on police officers to carry forward those misconduct investigations. There isn't another organisation that will do that for us.
No. Certainly in terms of the 2014 regulations as they apply, we can see that obligations, responsibilities fall on Police Scotland officers.
Yes.
As well, I appreciate there's a recognition that you want to avoid any potential conflicts, bias of some description. Yes. We've also heard that Police Scotland is a hierarchical organisation. People feel loyalty to their colleagues. They can be facing very stressful and difficult situations, sometimes on a daily basis. And there may be a sense of collegiality, connections made. On that level, is there any sense that Police Scotland take a protective or a defensive approach when it comes to issues of misconduct, gross misconduct?
No.
Can you elaborate on that?
So, I think, back to the point about having an effective complaints and conduct and discipline system is absolutely fundamental to maintaining and upholding public confidence in policing. And certainly in my time in Police Scotland, yes, we've got things wrong historically, quite clearly we have got things wrong historically, but there have been a number of there's been a lot of progress made within the organisation in terms of the quality of officers who are in the professional standards department, the training that they get, the understanding they have about their core responsibility to protect public confidence in policing in Scotland, and also their own responsibilities as far as our values, fairness, integrity, respect, a commitment to upholding human rights, the code of ethics, and indeed the standards of behaviour are concerned.
Thank you. And then earlier today you talked about, when I was asking you about the regulations, you talked about a matter in 2022 where there was a PERC investigation, and you talked about collaboration and a sort of working relationship that had developed. I'm interested in your views on that from the perspective of Article 2 and independence. If there's this increased collaboration envisaged when PERC are carrying out an investigation.
So that was not an Article 2 investigation, and I do think Article 2 investigations are very different. Clearly, if the PERC were to ask us for something, if they required something of us, then we would do our utmost to fulfil and discharge those obligations. But I don't want to speak for the PERC. I'm sure she will speak for herself. But I do think Article 2 investigations should be investigated entirely independently by the PERC. The collaborative approach is, if there is an offence committed by, potentially committed offence or series of offences committed potentially by a police officer which are not in the Article 2 space, but which, for example, require different premises to be searched, property to be seized, we can support the PERC to do that under the guidance and auspices of the PERC and the understanding that the investigation is their investigation, but we can assist in ensuring that is carried out. You spoke about the benefits of a prompt investigation. There are occasions where we can support the PERC to deliver those, but that is not in the Article 2 space.
So sticking with Article 2 matters,
yes,
which give rise to a requirement that there be an Article 2 compliant investigation. So sticking within that and that alone, Where misconduct issues fall within that, within the wider Article 2 incident, for example, do you think in that situation that it should be the role of an independent body of some description to deal with issues of conduct as well as maybe the wider criminal investigation?
I certainly have no issues with that approach. I have no issues with that approach in and of its own right. However, I would go back to and it's important. This is so important in terms of maintaining public confidence. But again, what I would go back to is the competence of and the independence of the teams who investigate or who carry forward conduct investigations within the Professional Standards Department. I have absolutely no concerns about their impartiality or their independence. If in the context of an Article 2 investigation, and of course this is a conversation to have with the PERC or potentially the Scottish Government, could there be seen to be benefit in having a wholly independent assessment of any conduct which might come out of that inquiry? I would not be averse to that happening. My consideration would be, given that this is potentially a conduct investigation following the gravest sort of set of circumstances that could ever happen when somebody has lost their life, the assurance that I would want is that whoever is carrying out that conduct investigation is properly trained, is skilled, is equipped and is experienced to do that, so that there isn't a suboptimal outcome at the end of it. Particularly for the family, but also, of course, for the officers as well, and then, by definition, public confidence.
And you think that if there was an independent consideration, an independent body, say, who considered the regulations and considered all the issues under those regulations, that independence would enhance public confidence?
I think You described the five facets of an Article 2 compliant investigation council. From my perspective, the more independence that can be brought into that environment, I can't find. I wouldn't want to argue with that. My concern would be that whoever PERC or skilled investigators, we'd need to, if it were to be PERC, need to be absolutely certain that those individuals tasked with any consequent misconduct investigation were as skilled in that environment.
And if they were that skilled, you would have no objection to that?
It's about the best outcome for the family of the deceased. It's about upholding public confidence, and of course there is also the fact that we would not want officers to be then challenging the conduct process, which is back to my point about skilled, experienced, and whoever does it, skilled, experienced, and well trained.
Although the possibility of a challenge exists even for Professional Standards Department officers. In relation to the second procedural obligation under Article 2, that relates to the adequacy of the investigation. Now, given what you've explained to us today about the issues under the regulations being deferred at various stages for various reasons, and potentially until the end of this inquiry, with regard to adequacy, can you help me understand how you took the view that this aspect of Article 2, the aspect of the regulations, was going to be adequate if there was simply no assessment and no consideration being given? So
as I've mentioned, we have had a go. This isn't about no kind of regard for the circumstance. We've had a goal group, as I've explained to you, set up for years now with that overview of the circumstances of all of the different elements that have led us to the public inquiry. My overarching ambition, however, was that the criminal proceedings, all of the circumstances around the criminal proceedings, Crown's consideration, all of those really significant issues which have to properly be carried forward when there is a death at the hands of the state, a death in police custody, or a death following police contact, those are all able to run forward and to reach a conclusion. And that took some time, as we know. The adequacy of any sort of conduct regulations in terms of any conduct that may or may not arise as a consequence of the circumstances in 2015, I do think it's appropriate, as I say, that the criminal investigation is allowed to complete, and now the public inquiry is allowed to complete. At the end of that public inquiry, Council, we will then have an understanding of the entirety of the landscape that pertains to the events of 2015.
And in terms of adequacy, obviously the regulations will, on what you've said, I appreciate you're now retired, but you'll consider matters, Police Scotland will consider matters under the regulations, potentially up to 9 or 10, well, it's already 9, perhaps 10 years after the events.
So I think that's right. I think a lot of that timeline is absolutely outside of the gift of Police Scotland. That has been as a consequence of the way matters have unfolded since 2015. Highly regrettable, I think. But I'm also very conscious that had we, for argument's sake, been engaged in disciplinary procedures or conduct procedures with the subject officers at the same time as they were being called to a public inquiry to give evidence to the chair, then I think that could actually have had a deleterious impact on the quality of the evidence that they provided to the public inquiry, which I think is incredibly important to support Mr. Bayo's family understanding the truth and the entirety of the events of May 2015.
So certainly from the moment in time that the announcement was made about the public inquiry, that could be one factor. That would be from 2019. Prior to the public inquiry being announced, what were your concerns about conducting contemporaneous parallel misconduct proceedings between 2015 and 2019?
So again, I think we go back to, and please do correct me if I'm wrong here, Council, the fact that the PERC had carried out that contemporaneous investigation. We talk about the adequacy of any investigation into a death, but also the adequacy of any further or follow-on conduct procedures. We hadn't had disclosure of that contemporaneous material from the PERC. We didn't get that until relatively recently, as you know. I do think it's suboptimal to go back and to try to take statements, as you've rightly said, some 5-6 years after a series of events and try to work through a misconduct process based on those. I do think that would undermine the adequacy and the professionalism of any conduct investigation. So I think there are a series of just in terms of the timeline around all of these events, there have been a series of issues, decisions taken, by a number of actors that mean that there have not been discipline proceedings taken forward to date. As I said to you just before the break, and it's quite clear from the letter that I sent on behalf of the Deputy Chief Constable to the chair of the inquiry, we are not ruling anything out at the conclusion of the inquiry or indeed at any point beyond that. Your point about timeline, again, I'll come back to this, is absolutely correct, but that timeline does not necessarily sit within the gift of Police Scotland.
So the third procedural obligation is that the investigation should be reasonably prompt. Would you agree that taking up to 9-10 years is not what one would consider reasonably prompt?
Without a shadow of a doubt.
Looking at matters now as they have panned out over this period of time, do you think there are ways that Police Scotland could have dealt with the conduct regulations more efficiently, more quickly than has actually proved to be the case?
So again, I think So I think we're going back, certainly from my perspective, to part of the conversation we had this morning, which is the preeminence of the independent Article 2 investigation, the determinations that might be made by senior Crown Counsel about whether there should be potentially any criminality or any charges brought in terms of any of the officers. I think conduct is very much in the foothills of that. I think the criminality, potential criminality, whether or not Crown determine that there is criminality, the potential for that criminality should take precedence. So we are talking about a relatively sort of small period of, from my perspective, very, very difficult for the family, and I absolutely empathise with that. But again, over that period, there were a number of issues that, in terms of access to documentation and the like, that was not that just wasn't available, just were not available to us.
Do you, in your experience as a DCC, have you come across any other situation where officers have waited over 9 years before proceedings are considered under the 2014 regulations?
So I don't think so I guess there are two issues there, Chair. In terms of a set of circumstances occurring and us being aware of those circumstances, then no, I think this is quite unique. Colleagues will be aware of the fatal accident inquiry into the recently resulted in terms of the M9. Again, that was around about 2015. Of course, there are issues where there are historic allegations made against police officers that suggest that they may have offended before they joined the police service, or and those don't come to light until a number of years later potentially, and will then go through the criminal and conduct processes. So that timeline is not the circumstances surrounding, and you said it yourself, the circumstances surrounding the death of Mr. Bio and the subsequent processes and procedures which have taken place, including the public inquiry, are quite unique. And the timeline, from my perspective, is quite unique. I am aware of circumstances in England and Wales where young black men have died in police custody at the hands of police officers, and again, those proceedings have been incredibly protracted, both for the families of the young men, and they are predominantly young men and they are predominantly young black men who have died in police custody, and ultimately an outcome either for the families concerned or indeed the officers concerned.
For officers who have waited perhaps 9, potentially 10 years, they may be looking at reaching retiral age. For those officers, as the law presently stands, if they retire or leave the service, there will never be any misconduct proceedings instigated under any circumstances against them.
So that's absolutely correct, Counsel. Again, as we discussed this morning, let's assume that we are in an environment where potentially a misconduct investigation is extant. That would not stop. And this is not saying that there is any conduct found against any officers, but even if a conduct investigation was ongoing, that would not prevent officers, as we discussed this morning, resigning or retiring in any effect. But that is not to say that I am comfortable or content with the timeline, because that is not the case.
And if at the end of this inquiry, time is taken to prepare the report, as it obviously will need to be, and at the end, when the report is published and the findings made known, if at that stage the Crown then take a view that they wish to reflect on issues of criminality once more, would Police Scotland wait a further period until that assessment had been finished by the Crown?
That's not a decision that would be taken by myself, Counsel.
No, you. Was that something that you were anticipating, that additional delay, depending on what the Crown's view would be?
I hadn't actually got to that stage in my thinking.
Right, okay. So the next procedural obligation under Article 2 is public scrutiny. Now, we're hoping to hear from Lady Angelini later in this hearing, and I wondered about whether you consider that there is sufficient public scrutiny embodied within these regulations. And I think, as I understand, we may hear that Lady Angelini has made a recommendation about gross misconduct hearings should be in public. And I wonder whether that was something that you were considering before you left.
So, again, when I was a Deputy Assistant Commissioner in the Metropolitan Police Service, that was at a point in time where police regulations changed in England and Wales, and I was actually responsible for introducing gross misconduct hearings in public into the Metropolitan Police Service. All of which was done in England and Wales similarly to Scotland, with the view of enhancing public confidence, trying to, if you like, do away with the veil of secrecy, particularly around gross misconduct hearings. My experience in the Met was that actually, unless the hearing was particularly iconic or something that now this I have to say was when I was a DAC in the Met, which was up to 2017, the approach that the Metropolitan Police Service is taking more recently to their conduct processes has obviously changed since the time that I was in the Metropolitan Police Service. However, what we found was that bringing gross misconduct hearings in public into the Met didn't actually engender an awful lot of public interest unless it was a particularly iconic gross misconduct hearing. So I have absolutely, providing that we can get the proper safeguards in place for witnesses, particularly with those witnesses in gross misconduct hearings who may be complainants, and particularly given that a significant number of the gross misconduct investigations which are ongoing in Police Scotland at the moment involve abuse of authority or abuse of power imbalance in some shape or form. It's absolutely fundamental that if we do hold gross misconduct hearings in public, which, as I say, I have no inherent disinclination to do, we provide the safeguards to those who are going to come and provide testimony, witness evidence, which potentially might mean that a subject officer is found guilty of gross misconduct and loses their job, that we provide them with the environment where they feel safe and secure and confident and competent to do that. Because actually, I think it's a bit of an own goal if we're holding gross misconduct hearings in public, but we don't have that support for the key witnesses who we need to come and give evidence in order for the hearing to function appropriately.
And in terms of the regulations, we've touched upon in your evidence the involvement of the next of kin. We've talked about, but at the moment, thinking about public scrutiny. Obviously, next of kin are members of the public. To what extent do you feel, looking at these regulations and knowing them as you do you feel that there was sufficient opportunity for the public to question, challenge, the family to question or challenge decisions that were taken in terms of the regulations, or where decisions are not being taken in terms of the regulations?
So, I mean, I do think there is a lack of transparency around the conduct regulations in Scotland at the moment. I also think the 2014 regulations, it's a personal view from a retired police officer, the 2014 regulations are better drafted than the 2013 regulations, which were drafted obviously to coincide with the inception of Police Scotland. However, at the moment, the issue for me is the sort of confidentiality and the technicality around those regulations, Council, and to make them more accessible, to help members of the public, family members, to understand how the process works. I think that can only be a good thing. Again, what we have done recently in Scotland is publish the outcomes of gross misconduct hearings. Now, we haven't waited for any regulatory framework to enable us to do that. We have waited until the process is concluded. We have then anonymised the outcomes in terms of the officers that they refer to, but we have put into policing and into now, I don't know whether they are forward-facing on the Police Scotland website, but what we have done is attempted to be much more transparent around gross misconduct outcomes in order that colleagues can learn from those.
And then finally, the final procedural obligation is in relation to involving the next of kin. Now, I've asked you a couple of times about whether approaches had been made to the family to find out what their views were. You mentioned at one point you thought it was appropriate that the lawyers perhaps be approached. Again, thinking very much about an Article 2 scenario, do you think, looking at the regulations, that there would perhaps be more opportunities for the next of kin's views to be considered by Police Scotland, maybe on a more formal basis?
I think on a formal basis, yes, because goodness knows, in circumstances such as these, people will be properly emotional, absolutely enveloped, if you like, by the tragedy which has overtaken them. So, yeah, I certainly think there is opportunity for, the legal advisors of, bereaved families to put and back to that in a second, but the legal advisors of bereaved families to put the concerns, the feelings, the desires of the family forward. And in fact, I think the letter that we have discussed a couple of times this afternoon in terms of requests for undertakings actually does reference the views of the family through Miss Mitchell.
Yes.
Now again, how that happens in practice in terms of the regulatory framework would obviously have to be worked through.
Yes. I'd like to move on away from Article 2 to some extent. We've heard evidence about Article 14, which is triggered in conjunction with Article 2. And I'd like to talk to you about the issue of race. Obviously, when I spoke to you this morning, we looked at the standards, we looked at equality and diversity, and I specifically asked you if that included issues of racial discrimination, which you confirmed it would. So we know that that aspect of the standards of professional behaviour is very much part of the what is Schedule 1 of the regulations. And could we look at paragraph 6 of your inquiry statement? I think you've said at the very end of that paragraph, and it sums up, Police Scotland had a zero tolerance approach to racist behaviour. Now, that's very straightforward. And then if we could look at page 3 of the letter that we were looking at earlier, this is the letter to the Chair from March 2022. And if we can look at page 3 of that, sorry, I've got it. Page 3, and I'm interested in paragraph 3. The Chief Constable has made it clear that racism or discrimination of any kind is deplorable and completely unacceptable. It should have no place in society, and it has no place in policing. Any perceived failure to further the policy of zero tolerance within Police Scotland of racist views or discriminatory attitudes would seriously undermine the confidence of every community in Police Scotland. It would be highly damaging to the integrity of the service and the rigour with which that policy of zero tolerance is discharged between and among police officers and members of police staff. It would be antithetical to Police Scotland's values of integrity, fairness and respect, and contrary to our commitment, reflected in the police officer's declaration to upholding human rights and a shared mission to keep people safe. I'm not sure I said that right, but anyway. We've also heard in the opening statement from the Chief Constable that Police Scotland wish to be anti-racist. So these are very strong public statements made by and on behalf of Police Scotland. And you indicated in the opening statement through Council that holders of the public office of Constable are subject to a strict regulatory framework which is essential for the preservation of public confidence. And you also said a rigorous adherence to legal duties will be continually assessed and evaluated for effect. So again, very strong public comments about racial discrimination and how it's not acceptable to Police Scotland. Now, we've heard evidence about Article 14 and the impact of Article 14 in relation to PERC and Crown Office. And we've heard, and its witnesses have agreed, that as part of the obligations under Article 14, that you must take all reasonable steps to unmask any racist motive. So racial motivation is a thing that has to be rooted out.
Absolutely.
And that aspect of any investigation, of an Article 2 investigation, must be pursued with vigour. And we've compared that description of Article 14 and the obligations of that in conjunction with Article 2 with the actions taken by PERC and Crown Office. And I'd like to ask you, if you take that statement of Article 14 in conjunction with Article 2 from me, how you consider Police Scotland's approach to the 2014 regulations may or may not comply with the Article 14 obligations.
So again, I think when the events of 2015 occurred, the issue of was race a factor in the death of Mr. Bio should absolutely have been part of the considerations going forward. At the time, the incident, the instant and tragic set of consequences from that incident occurred. So
race should have been part of the investigation if it was to be Article 2 and Article 14 compliant.
That's again, I wasn't in Police Scotland
No.
at the time, but that would be my view.
That was the position then, and it would have continued to be the position throughout the period to now.
Yes.
And we know under the 2014 regulations that racial discrimination is a feature. It's something that, if that exists, it would run foul of the Schedule 1 standards of professional behaviour. In what way have Police Scotland, insofar as they have control over these regulations and the issue of misconduct, in what way have Police Scotland taken all reasonable steps to unmask any racist motive or to pursue these issues with vigour? Given what you said, that no consideration will be given until the end of the inquiry, or perhaps beyond.
So again, Council, from my perspective, given that the inquiry's terms of reference talk about, was race a factor, I would not want anything. We can go back over the availability of documentation, the timeline and the like that we have already discussed and described. Given the terms of reference of the public inquiry itself, we certainly would not want to cut across those. What we are doing within Police Scotland is absolutely looking at what it means, and this is learning for us already and commitment for us already out of the public inquiry. Leave the subject officers within the public inquiry to one side for the moment, but certainly the learning for us to date from the public inquiry and also from the work that we have done under the auspices of Policing Together and the EDI, the Equality, Diversity and Inclusion Strategy within Police Scotland, tells us very clearly that there is work to be done for us organisationally to become a truly anti-racist organisation, to understand what that means and to integrate our determination to become an anti-racist organisation into every element of policing activity. Now, I don't think that was the case in 2015. I wasn't here. Certainly the work that I have done the work that I did in my tenure in Police Scotland very much focused on how do we become a different organisation, a better organisation, an organisation which actually understands what it means to be anti-racist and what that then means in terms of the discharge of those powers and responsibilities that are vested within police officers, and also what that means in terms of the culture within the organisation to ensure that it nurtures, supports, values and progresses every single individual police officer or member of police staff within the organisation.
And talking about learning from the inquiry, you've said to us earlier today that you were really in charge of liaison with the inquiry and handling the inquiry. And I don't wish to explore any matters that may be privileged or confidential, but would you be able to share with us the process which you have adopted to learn from things that come out during this inquiry?
Certainly, I think I'm looking at the Police Scotland legal team as I speak, Council.
I don't want to encroach on anything that may be privileged. I don't believe this will.
But no, that process, and that was one of the kind of the key responsibilities which I felt I had, was to learn and to assist the organisation to learn from the public inquiry. Now, I think there may be a colleague called to talk about organisational learning at some point, Council, but yet certainly we can explain in some detail, because there was a significant amount of work ongoing in my tenure in Police Scotland that resulted in changes and upgrades to policies and practices, particularly those which were engaged around 2015, and which have subsequently, as I say, been upgraded and improved. That's fundamental learning for us from the inquiry, and very happy to share that to date. From the inquiry to date, very happy to share that with you.
Thank you. And am I right in thinking that notes have been taken during the course of the inquiry and improvements have been made on an ongoing basis, and Police Scotland have not simply waited in terms of making improvements until the end of the inquiry?
I think that's absolutely right. And if we were to look specifically, for example, at the family liaison officer, and how a family liaison officer is trained, how they're deployed, their understanding of cross-cultural communication, how they might engage with a member of a black or minority ethnic community who has lost a loved one, whatever circumstances. Those policies have been actively worked upon over the course of the inquiry. That's just one example. The operational safety training, as I think you've heard, is constantly being upgraded, as is the Scottish Police Emergency Life-Saving training as well. So there are a number of different policies, practices and procedures which are being reviewed over the course of the inquiry. What I would add to that is that one of the elements of the Equality, Diversity and Inclusion strategy, which was given effect in Police Scotland, or given effect to in Police Scotland, I think it was in early 2022, talks about us constantly going back and reviewing policies, practices and procedures to ensure that they are anti-racist and that they do not unwittingly discriminate against anybody who is from a different minority, ethnic or black background. And indeed that also refers to other, people with other protected characteristics as well.
Thank you. I'd like to go back to one thing. I asked you previously about disclosure of the PERC report,
yes,
and when that took place, and what steps, if any, had been taken after that. And it may be that if I ask you about this, it will prompt a memory with you. Although much disclosure is given by the inquiry, there is something known as a restriction order, which precludes that information being disseminated publicly. Did you take a view that that restriction order would interfere in any way with your obligations under the regulations?
I genuinely don't know. I can't answer that.
That's fine. Now, we've talked about the Gold Group, and I'd like to move on to that. Let's look at your inquiry statement, and if we look at paragraph 8, please. This Gold Group had been formed prior to my appointment to Police Scotland. It was concerned with issues including community engagement, the overview of ongoing legal matters, overview of any internal investigations and processes, situational awareness of ongoing media coverage, and the welfare of the officers involved. And that seems to be a broad remit for a group. So we've heard about other gold group meetings that took place at a very early stage,
Yes.
after the 3rd of May 2015. Is this a different type of gold group?
Yes, it is. The reason we still had a gold group, and that gold group matured and evolved again, Council, with the as we understood that there would be a public inquiry in order that we could, as Police Scotland, commit to the Chief Constable's, the then Chief Constable's aspiration to be as supportive and transparent with the public inquiry as Police Scotland possibly could be as a core participant. But that was not so that was not a critical incident goal group, if you like. This was a goal group which was still set up, which clearly had come about as a consequence of a critical incident. But we were now some number of years on, so this was really to ensure that we still had, and we mentioned this earlier today, that Police Scotland was still well aware and was not forgetting. At the highest levels within the organisation of the events of May 2015.
So although the reference in your statement seems to suggest this is a very large remit, is this all to do with the death of Mr. Bio?
Yes, it was. Yes, it was. Now, as I say, that the goal group, its terms of reference were expanded when we knew that the public inquiry was going to take place, but this was to do because we knew at some point we were either going to get the material back from the PERC, there was going to be an assessment carried out, or there was going to be a fatal accident inquiry, or indeed a public inquiry. So it was very important that we maintained that overview from a Police Scotland perspective of the events and the circumstances of 2015.
So when earlier I was asking about public concern and how that was being weighed and assessed and considered, and you talked about the group engaging with community engagement, this was done through this gold group.
So the gold group took the product in. The engagement would be done locally, as we said earlier, either by the divisional commander responsible for the division that the event occurred in, but also we have or certainly we had at the point in time when I was in Police Scotland, a preventions and community wellbeing division as well, which would take a broader look across the country at any issues around community cohesion or community engagement. So locally and nationally, and the product fed into the goal group, which would enable me, if I wasn't happy with the product, to go back and ask for a bit more detail or a better understanding of what might be happening in Kirkcaldy or other parts of Fife, for example.
And you were the chair of the gold group?
I took responsibility on to become the chair of the gold group when I moved into the organisation, yes.
Who's involved in the gold group?
So, it was an iterative process, as I say, the gold group. And when I took it on to, when I passed the chair over to ACC, now DCC Spears, when my responsibilities and portfolio changed. If we talk most recently, Council, about that goal group, it would involve my deputy, ACC Spears then, who's responsible for ensuring that sort of tactically we were preparing properly for the public inquiry. It would involve, and did involve, the ACC, who was local to the division in which the events of 2015 had occurred, and again to ensure that the community cohesion, community tension, any issues that might be arising on that division, we had a proper oversight of and understanding of. There would also be legal representation on that group to ensure that actually we were getting the proper advice and ensuring that any decisions that were taken were appropriate and lawful. And equally, just simply because of the length of time, and we've alluded to this already, that the goal group had been running for and the time that the various investigative processes had been running for, just to ensure that there was a consistency in approach throughout. We would also have colleagues from corporate communications sitting within that group as well, and very latterly we would have just looked to have an understanding of finance and costs around the various different sort of processes and inquiries that were ongoing.
Thank you. And then can we look at paragraph 3? And you talk about, Dame, as she was then, Dame Ailish Angelini's independent complaints review in 2020. And you say, paragraph 3, I set up the Equality, Diversity and Inclusion EDI Oversight Board in March 2021 to bring together internal and external aspects of new and ongoing activity to counter discrimination and focus on the issues of equality, diversity and inclusion. And it says the Oversight Board consisted of chief officers from across Police Scotland, as well as external interested parties, HMICS, the Scottish Police Authority, members of the Independent Review Group that had been created following the Dame Ailish Angelini Independence Complaints Review in 2020, statutory and non-statutory staff organisations, colleagues from People and Development, colleagues from PPCW, which was tasked with coordinating community-facing EDI activity, the National Police Chiefs Council, Chief Officer, responsible for creation of the England and Wales Race Action Plan, was also invited to attend so we could learn and share good practice with colleagues in Home Office forces. So the Oversight Board, am I right in saying that arose out of the Dame Ailish Angelini Complaints Review in 2020?
No.
Oh no?
No. Right. No. So the EDI Oversight Board was set up because the chief one of the key tasks that the then Chief Constable gave me, counsel, was to enhance organisationally our understanding of race and diversity, inclusion matters, and also to address a number of issues which were extant in Police Scotland at that time. So there were almost two train tracks running in parallel. Dame Ailish was carrying out her investigation, and at the same time I was in Police Scotland striving to understand what the culture of the organisation was. And one of the ways I did that was by speaking to numbers of black and minority ethnic colleagues who started to give me an understanding of how the organisation felt for them. And that was one of the key drivers of setting the EDI board up. One of the other key drivers was that actually at that point in time, and no disrespect whatsoever to my predecessors, I felt that EDI activity was scattered about the organisation and wasn't actually as coherent as it could be, and as a consequence of that wasn't likely to deliver the effect that I felt needed to be delivered across the organisation in order to ensure that we could actually impact positively on the culture of Police Scotland. So when Dame Ailish provided her sort of recommendations, actually the recommendations around the experiences of black and minority ethnic colleagues were absolutely aligned to what I had been told directly by black and minority ethnic colleagues in the focus groups that we had set up, precursor activity to the EDI board, which obviously then became the Policing Together Oversight Board. So as I say, there were a number of activities running in parallel in Police Scotland at that point in time.
So a number of parallel activities in relation to this issue of EDI. As a result of that, as a result of Dame Ailish's report in 2020, a number of factors came together and culminated in the setting up of the Oversight Board in
Yes.
March 2021.
That's absolutely correct, and you'll see from the number of individuals who were invited to attend that board, it was a really significant strategic board within Police Scotland at that time, and reported into the preeminent senior leadership board on a monthly basis through myself giving an update on EDI activity in the organisation.
Thank you. I'm conscious it's now 4:15. Would that be an appropriate time?
Yes, well, we'll stop there and we'll continue with your evidence tomorrow morning at 10 o'clock, Mrs. Taylor.